The next case is Tomra of North America versus the Department of Treasury. This is a full grant, and we have 20 minutes of argument per side.
Good morning, Your Honors. Madam Chief Justice, I am Assistant Attorney General Randi Merchant, appearing on behalf of Defendant Appellant, Michigan Department of Treasury. At council table with me is Assistant Attorney General Scott Damage and Deputy Solicitor General Eric Restucia. We ask this court for a determination that we ask this court to find that the determination of whether industrial processing is occurring must not be made by looking at the language of subsection 3 of the industrial processing exemption in isolation, and clarify that the list of activities in subsection 3 must be read in context with the language of subsection 7, which is the definition of industrial processing, and describes it in terms of both an activity and a required time frame. Doing so would be consistent with the rules of statutory construction that have been in place in Michigan for decades. It would honor the intent of the legislature with the overall scheme of the exemption, and it would also be consistent with Treasury's interpretation of the statute. And as the agency that interprets the statute, their view is entitled to respectful consideration, as Justice Markman recognized in the previous case. The property that is issued in this case are bottle return machines. It's familiar to probably everybody in this room. People go to grocery stores and other locations that sell beverage containers at retail to return the items to get their 10-cent deposit back. The machines do not accept every bottle or can that is presented by a consumer. It can reject them if the brand is not sold at that store. The containers that are accepted, having been accepted by the machine, are then picked up by a third party, taken to another location operated by another entity, and that entity will treat the cans and bottles as a commodity, which is again sold to another entity, which at that point is finally made into a product for sale at retail. Under the taxpayer's theory, the grocery stores or the individuals that are returning the cans and bottles are engaged in industrial processing more than 3 steps removed from the process that will actually turn these cans and bottles into an item for sale at retail. This would be an absurd result and not consistent with the overall purpose of the statute and the legislature's adoption of the temporal requirement in the second sentence of subsection 7. The legislature's adoption of that second sentence is key because when the statute was amended in 1999, adding the list of activities in subsection 3, they also consciously added that timing requirement. The list of activities in subsection 3 were consistent with the administrative rule that previously existed, Administrative Rule 90, that identified all of these activities as possible industrial processing activities and had not been in the statute up to that point. When the legislature decided to codify that rule, they added the language identifying the beginning and the ending of industrial processing. Beginning and ending those words must be given meaning. It makes clear that the legislature wanted to draw lines as to when this exemption was available.
Counsel, I think you concede that the first sentence of Section 7A doesn't apply to Section 3 activities. Is that correct?
Justice Markman, is your question that the first sentence of subsection 7, the description of the type of activities, would not apply to subsection 3? Yes, Your Honor. We do concede that some of the activities that are listed in subsection 3 are not within that traditional definition of industrial processing in that first sentence, which talks about converting or conditioning or essentially changing the physical characteristics of property. And some of the activities that are listed in 3 honestly, we can't argue, don't fall within that. But we do think that the statute can be harmonized by recognizing that those list of activities in subsection 3 must still fall within the temporal requirement of the second
I guess that's
sentence.
my question. Why then does the second sentence of section 7A apply to those same activities? What is it about the distinction between the first and the second sentence that leads you to the conclusion that the first one may not apply, but the second sentence does?
My response to that, Your Honor, is that the definition of subsection 7 says industrial processing means, which is the traditional language we would see in a definitional section, and talks about type of activity and then timing of the activity. And the introductory language of subsection 3 says industrial processing may include the following activities. It's limiting the discussion of subsection 3 to types of activities, which is addressed in the first sentence of subsection 7.
This is really an odd statute, right? Where the
Yes, Your Honor.
legislature, they define industrial processing, and then they give examples of it that don't meet their own definition, right?
The industrial processing statute is one of the most complex and frequently litigated tax statutes, and I am not going to try to convince anybody in this room that
Oh,
it's an easy
Yeah, it's an odd
statute to
statute
navigate.
for all of us to have to make sense of, so,
Try reading 6W of the energy.
oh, that one's easy. That one's easy. So one way of thinking about the statute is that subsection 3 and subsection 7 are in conflict with one another. In other words, one says these activities are exempt, and the other says these same activities are not exempt.
Our
Would that be
position,
a correct way of looking at it?
our position is that if you view that they are in conflict and cannot be
Well,
reconciled,
then you put an if in there. I'm asking you, are they in conflict? What do you think?
there is definite tension between the two. We would like to harmonize them, but
I
if
mean, we have
they
a
are in
spectrum of
conflict,
tension, right, that sort of starts with sort of a little bit of tension and a lot of tension, and then we could even say irreconcilably conflicting, meaning that they're ambiguous, right? So my question to you is, where on that spectrum do you think those two provisions find themselves?
there is some conflict between the two. I mean, because there are activities that are described that don't fit within the two. And when there is a conflict in a tax statute, it must be resolved in Treasury's favor. So that would not be,
Says who? If there's an ambiguity, the state wins?
if there
Taxpayers
is an
out?
ambiguity in a tax exemption statute, the state wins.
So
This
if
is
it was a-
because tax exemptions are disfavored under the law.
So if it was a tax statute, the taxpayer would win, but because it's a tax exemption statute?
That is,
Treasury wins.
that is absolutely correct, Justice Viviano.
Okay. But
Taxing statutes that impose a tax.
have we ever said that?
Yes, we have in several cases.
The Michigan Supreme Court has. Can you tell me
the-
what case?
The Michigan Supreme Court has absolutely recognized that, and so has the U.S. Supreme Court. When there is a limited, oh, actually, let me just,
Ambiguity in a tax exemption statute means that the state wins.
yes.
Why is there invariably a conflict when a statute lays out some test or standard for coverage of some kind of activity, but then in that same statute says, oh, by the way, there's some exceptions to this too. We're going to have the application to certain other kinds of institutions, even though they don't meet the standard that we've otherwise laid out. What's wrong with that? Is that an extremely exotic way of looking at the law?
It may not be viewed as an extremely exotic way, Your Honor, but because of the type of statutes that we're dealing with in this case, being a tax exemption statute, it must be narrowly construed because tax exemptions are disfavored. They are an exception to a previously clear statement in another section of the Sales and Tax Use Act that imposes a 6% sales tax obligation or use tax obligation, depending on which act we're dealing with, for the purchase of tangible personal property. That is the standard rule. This is the availability of a particular taxpayer to avoid the obligations of that standard rule. And in order to get the benefit of it, they must meet all of the requirements. And if there is conflict in the statute or if the language is somewhat unclear as to whether or not a particular circumstance would qualify or would not, the law must be drawn in favor of Treasury's position.
If there's an ambiguity, if there's a conflict, I don't know what's unclear about Section 3 or what's unclear about Section 7. I don't see any reason they can't be easily harmonized and allowed to stand side by side with each other. And I also don't quite understand what you mean by giving a narrow meaning to a tax. What was the standard you had for a tax statute?
Tax exemption statutes
Yes.
cannot be read, excuse me, they cannot be expanded by implication or narrowed by implication. And if there is a equally reasonable view of how to apply the statute, Treasury's interpretation must succeed. The more limited view must succeed. And that is consistent with
But all these standards of the law, don't we, by which we give meaning to the law, other than looking at the language and the inferences that can be reasonably drawn from the language. We had that in the last case, and you just referred to that. In this case, we also have to depart from what would otherwise be an ordinary approach to giving meaning to the law, right?
even under the normal approaches, Your Honor, we believe that our position is consistent.
Well, it may well be. I guess I think that would be the better way of proceeding on this case if that's what you felt. But, you know, if we've got all these default principles, I guess it makes sense for you to cite those. I'm just not sure I see the basis in the law for all these alternative default principles that you would impose upon the court in giving meaning to the law.
What we are trying to address some of the arguments that the taxpayer is making and characterizing subsection 3 as perhaps a more specific definitional statute. We don't believe that it is. We believe the definition is in subsection 7, and the definition provided for in a statute should control the outcome of a case.
But we only look to the more specific default rules or the later in time default rules when we're convinced there is some incompatibility, that the two provisions just can't stand logically alongside each other. I don't know that you've demonstrated that there is that same illogic here, that inexorable illogic, such that we have to reconcile them in some way such that provision A prevails over provision B, or the opposite.
Your Honor,
Well, I'm getting you off on a tangent, please.
Would the statute be more easily understood if the provisions of 7A came before the language of inclusion in subsection 3? In other words, industrial production means this, and it includes that. And are we getting a little bit confused when it says it includes this, and then it means that?
I think the organization of the statute can contribute to some of the confusion in this case. For whatever reason, the legislature opted to put all of the definitions at the end of the statute. So you are reading through, and the statute is saying industrial processing activities may include before it defines what industrial processing is. But if you start your analysis by looking at the definitions, which the definition set forth in a statute controls the outcome, the definitional statute describes industrial processing in terms of activity and timing. That timing requirement is key, and it helps define the limitations of the availability of the exemption. If you look at the exemption as a whole, and as Justice Viviano pointed out, this is not an easy statute to work through, but when you read it as a whole and you break it out into its different parts, it's clear this was not intended to be a blanket exemption for every purchase of property that is somehow connected with industrial processing. There's an apportionment requirement in subsection 2. There's an identification of eligible activities in subsection 3, but there's also an identification of ineligible activities in subsection 4. They specifically call out types of property that are eligible and other types of property that are not eligible. And this language taken as a whole, you can see where the legislature wanted to have limits. You wanted to draw a box around who, when, and what.
If we could see that, we wouldn't be here today, right? If the legislature had said that the definition, you know, the specific examples were subject, in 3 were subject to the definition in 7, then we wouldn't be here, right? But it didn't say that. My question to you is, because we've had an interesting debate about whether there's a conflict or not, would you agree on behalf of your client that it's clear, in fact, it's beyond debate, that some of the things that are specifically included as industrial processing under subsection 3 would not be allowed under subsection 7? I mean, isn't that the very position you're taking today?
We acknowledge that, Your Honor. We
So they're
specifically
clearly
reviewed-
in conflict,
And they
directly in conflict with one another. It's beyond debate that there's a conflict in the statute. Wouldn't you
There
agree with
is a
that?
conflict in the statute, and the conflict must be resolved in Treasury's favor.
Well, that's a different question. That's open to some debate. The first point I don't think is open to much debate. And in fact, one of the very subsections, examples are things that we're talking about today, recycling.
Yes, Your Honor. Recycling is
included under subsection 3. But you're telling us here today that under subsection 7, it's hard to imagine when, or many situations when recycling would fit subsection 7, right?
in the language that's provided for in the first sentence of subsection 7, it is not clear that the general concept of recycling would fit within there, yes.
Yeah, so that which the legislature gave with one hand, it has taken away with the other, right?
Yes, and as an exemption statute, it should be narrowly construed.
Why don't we, if it met irreconcilable conflict, I would say it's ambiguous, and then we'd move on to that analysis. I'm not afraid of that analysis. In fact, I think sometimes it's just where we find ourselves. But before we get there, why doesn't the provision that we should give precedence to the more specific provision over the more general prevail? Justice Markman did a very good job of describing that canon, I think, in the DTE case. Why doesn't that apply here to resolve the conflict in favor of the taxpayer?
Your Honor, I believe that the general principle of specific over more general applying, we recognize that that is the law in Michigan. However, we do not view this as a more specific definition because
Explain to me why. We have general definition, we have a very specific thing that's included here, right?
the definition of industrial processing in subsection 7.
That's not a general definition?
It is a definition of industrial processing and has two components, activity and timing. And subsection 3 speaks only in terms of activity. So it may be a more specific provision in the concept of activities that qualify, but those activities still must fall within the temporal requirement set forth in the second sentence of subsection 7, which the dissent at the Court of Appeals recognized.
If it's so clear that it has to meet the second sentence of 7, how would you account for our holding in DTE related to electricity, which we said never comes to rest in finished goods inventory storage, and therefore, it seems to me, doesn't meet the requirements of the second sentence of subsection 7?
Your Honor, our view of the DTE decision is not that it threw out the timing requirement in the second sentence of subsection 7. In fact, in a complete reading of the statute, recognized that the second sentence must be met. And while they recognize that the unique nature of electricity is going to prevent the traditional concept of inventory
Why doesn't the
storage,
unique nature of recycling mean we don't have to wait for it to move from raw material storage to begin industrial
I'm sorry,
processing?
I meant the unique nature of electricity in the DTE decision.
No, I know, I'm asking you, why doesn't the unique nature of recycling require us to reach sort of the same, or at least an analogous conclusion on the other end of the time?
It was the unique physical features of electricity that required the result in DTE, not the difference between recycling and the common concepts or the first sentence of the first sentence of subsection 7 that make it unique for the analysis. And the DTE decision identified the ending of the process as when the electricity hit the box for the customers. And the DTE court recognized that there may still be some modification of the electricity after that point, but took pains in footnote 6 to recognize that even though the electricity was subject to further modification after it was delivered to the meter, that modification was not IP. That was a specific recognition that the timing of the activity matters. Does that answer your question?
It does.
Okay.
Thank you, Counsel.
Can I ask you a question about a particular kind of manufacturing? I genuinely don't know the answer to this, so I'm not trying to trick you up in any way, but wouldn't your interpretation of the second sentence of Section 7A lead to the result, maybe an arguably anomalous result, that companies that engage in just-in-time manufacturing never truly engage in industrial processing?
No, Your Honor, I don't think that it does, because the Treasury has recognized that just-in-time manufacturing in their guidance will still qualify as industrial processing. There doesn't have to be a set, length of time for raw material storage. You can have an instantaneous placement into and removal from raw material storage to start the process. It's the idea that you need an identifiable beginning and an identifiable ending. And when, as here, you have a grocery store using the property 3 or 4 steps removed from the activity that's going to create a new product for sale, and at best, even if you wanted to view this as within the correct time frame to qualify for the exemption, at best, this is really storage of raw materials. This is not in-process storage. This is collection of the materials that are going to be used by someone else down the line. And subsection
But Counsel, I guess my
5
question
and-
is, I always like to try to keep it simple, and help me with this. The product is still being changed, though. It's being transformed. Isn't that the whole essence of it?
It is not simply a question of, is there any transformation?
Right.
You need to look at, what is that transformation? What is the purpose of that transformation? And in this case, the record demonstrates that, some of these cans may be crushed, but this was really more for the purpose of facilitating their obligations under the bottle bill and maintaining having less storage space, less shipping costs. The grocery stores are not engaging in this activity for the purpose on behalf of an industrial processor that's going to create a new product that's for sale at retail. This is beyond what was contemplated.
But
by
doesn't
the
it
availability.
ultimately, I think I hear your argument. I think I get it, but I just want to understand, though, but doesn't it ultimately does take on a new product identity, doesn't it? The whole idea is that it comes back in a different manner, right?
Can I do a friendly amendment to Justice Bernstein's question? In fact, isn't that the whole point of the bottle deposit law, that we would gather these products together and get them into the right hands so that they could be recycled, so that the finished good could be recycled and become raw material for another finished good? Isn't that the whole point of all this, or am I missing the point? Was it just for me to get my 10 cents back?
I would recognize that the result of the bottle bill helps facilitate recycling down the road. But the bottle
Isn't that the
bill
point
does
of it?
not
Wasn't it the
require
point of the-
recycling.
Wasn't that the point of the law?
The bottle bill doesn't contain the word recycling anywhere within it. And recycling
I
activities
mean, but it
can-
wasn't done to facilitate some other activity, was it? I mean, am I wrong? If I'm wrong, please tell me. But
I don't
all these
disagree
years
that
I've
that
thought-
may be the intention of the bottle bill down the road, is to support recycling, but it does not require the grocery stores to recycle. It requires the grocery stores to provide a deposit and then accept the bottle back, and that obligation goes up to the manufacturer or the distributor. And we would also not concede that the machines are actually used for recycling, as that term is contemplated in subsection 3, because these machines will reject bottles based on the same exact bottle.
I mean, I get it. I went to college, near the state line of Indiana, and we learned all about which bottles you can return and which ones you can't. And so I get it. So you go in the store with the wrong beer cans, and they say, no, we can't take those back. But why does that mean the right beer cans aren't being recycled?
Were you drinking beer in college?
No, not me. I didn't. My people I
have
knew.
no doubt.
People you know.
I saw people doing that.
Even, we don't think that the outcome of the case turns on whether or not the bottle bill facilitates recycling. This case should turn on whether or not Subsection 3 must be read in context with subsection 7.
I agree with you. We're trying to untangle this knotty statute. You guys are partially to blame, though, because they started on this road by taking your rule and then putting it into the statute. So you should be blaming your predecessors at the Department of Treasury.
I will write a strongly worded letter when I get back to my office, Your Honor.
Thank you, on behalf of at least myself.
Can I just follow up on my question about just-in-time production? I asked you a question about that a few minutes ago. I just want to briefly follow up on that. Your answer to me, to my concern that maybe companies engaged in just-in-time manufacturing wouldn't be able to satisfy the second sentence of Section A, and you said, not to worry, there's been some guidance, and instantaneous storage, otherwise known as non-storage, is somehow covered by the statute at this point. Where did this guidance come from, and is it designed to bear some actual real-world relationship with what the language of the statute says?
Your Honor, I believe that guidance is cited by both the taxpayer and Treasury in our respective briefings. It's part of the industrial processing manual that Treasury provides to the auditors for their review while examining taxpayers' operations to determine if they're exempt or not exempt. It may also be part of the frequently asked questions that's available online, but that is, I don't believe, part of the record, but it is. The IP manual is part of the record.
I quite understand why it's a frequently asked question. I'd be interested in seeing what their answer is, but thank you for the guidance that there is guidance.
Thank you, Your Honors, for the opportunity to answer your questions. If for some reason you are not persuaded by our arguments, we would just point out that the taxpayer's request for relief asking that the matter be remanded for entry of an order requiring that the refunded issue be paid is not appropriate because the order that led us to the court right now was based on the taxpayer's motion for partial summary disposition, and there are still other issues that need to be decided below. And the Court of Appeals recognized that when they reversed the trial court and remanded for further proceedings not inconsistent. So we just wanted to clarify that for the record.
Thank you, counsel.
Thank you very much.
Good morning, and may it please the court. I'm June Summers Haas of the Honigman firm. With me at council tables, my associate Chris Jacobson. We're here on behalf of Tomra of North America. So the application of the industrial processing exemption at issue to the container recycling machines is best determined by understanding the context of the industrial processing exemption and then just merely applying the plain language of the statute. And what I mean by that is the industrial processing exemption applies not just to industrial processors, persons who produce the consumer product for sale, but to other persons, and it applies across the scale. Now, the industrial processing exemption has been in the statute since 1933. In 1999, the legislature dramatically expanded the industrial processing exemption, and it helps, I think understanding that will help address some of your questions here today. Prior to the 1999 amendments, the industrial processing exemption only applied to industrial processors, those persons that created the ultimate product for resale. In 1999, the legislature expanded the exemption to apply to persons who are not industrial processors. And any person who is not an industrial processor who purchases equipment to perform an industrial processing activity for or on behalf of an industrial processor qualifies for the exemption. Or if the tangible personal property is intended for ultimate use and is used in the industrial processing by the industrial processor. Thus, any person, including grocery stores or any other retail store, that owns Tomra's container recycling machines will qualify for the exemption if the machines perform the industrial processing activity. Now, these changes to the law were made to allow not only the manufacturers, but fabricators, processors, and their service providers to claim the industrial processing exemption, even if the process of assembly or fabrication or servicing is spread across multiple persons, the activity is done at different times, and it's geographically separated. In addition to changing who can claim the exemption, it also added the subsection 3 list of 11 specific activities that qualify as included industrial processing. These are servicing type activities that are a part of an industrial process, but not necessarily done by an industrial processor. And in this case, the container recycling machines perform two of these newly added activities. One is the inspection, quality control, and testing of the bottles and cans to determine whether they meet the parameters for recycling. And the second is recycling itself. In this case, these machines perform the first steps of industrial processing for or on behalf of shoe pan recycling. Now, shoe pan recycling is a recognized industrial processor, and Charles Riegel, who's the vice president of Tomra, talked about what they do. They take a mixed stream of recyclables, blue carts, blue containers, they put it in a truck, the truck goes to their big processing plant, they dump all these mixed recyclables onto a large conveyor belt, goes into the processing plant, and they separate it out into separate streams of the recyclables, aluminum, plastic, sometimes cardboard, and then they compress and pack them, move it off to a baling, bale it all up, and then sell it off to manufacturers and reclaimers. In this case, the container recycling machines perform those first three steps on behalf of shoe pan. The container recycling machines inspect the bottles and cans. It does quality control and testing. It rejects things that are not properly recyclable. And then it separates them into glass by color, into plastic, the plastic by color, and then it's punctured and flattened, into aluminum cans that are then compressed. So at this point, we have a clean stream of recyclables that are delivered to shoe pan. And when they get to the shoe pan processing plant, they don't have to go through that big separating and sorting machine because they're already a clean stream of recyclables. They go directly to the baler, they are baled, and then they are, shoe pan, during the years at issue, as Mr. Riegel testified, had contracts with Alcoa and Coca-Cola to buy bales of these aluminum cans, with Owens, Illinois, and Veralia to buy the glass to remake glass bottles, and with other reclaimers to turn the plastic into plastic bottles or auto parts or rugs. So the container recycling machines perform two of the specifically identified and added industrial processing activities under subsection 3, the testing and quality control, and for or on behalf of an industrial processor, shoe pan recycling. It qualifies under the plain language of the statute. There's no ambiguity here. The department's argument that their advocated interpretation of this law violates the fundamental rules of statutory constructive. They ask you to say that there should be a selective application of a general definition over top of the specifically identified industrial processing activities, but not the entire definition. We'll skip the first sentence because that doesn't really work. We would render many of these activities nugatory and surplusage in contrast to the legislature's plain language, but we'll only apply the second sentence of the broad industrial processing definition. And then in their brief, the department even recognizes, well, we can't do that for all of the activities under subsection 3 because we disqualify them. At page 25 of the brief, the department says, well, engineering relating to industrial processing, that happens before raw material storage. So that will qualify because it's tied back to another activity that's related to the occurring within the time frame of between raw material storage and finished goods storage. Where does that standard come from? It's not in the statute. It's not written down anywhere. It's the type of selective, results-oriented, unprincipled application of a statute that should be rejected by this court. In addition, design or construction of machinery and planning and scheduling of production won't qualify if you apply a raw material storage prerequisite to the industrial processing exemption. It should be rejected. We should go with the plain language of the statute. In addition, the basic rule of statutory construction is not that the general controls over the specific, but the specific controls over the general. The legislature said these specific activities are industrial processing, but you do have to show you're doing it for or on behalf of an industrial processor, or you are an industrial processor. And so that is, in fact, what applies. We'd also note that the department's interpretation would disqualify currently exempt activities that are performed without raw material storage. As the Michigan Manufacturers Amicus Brief so eloquently stated, many processors have readjusted their production process to eliminate the costly and inefficient accumulation and storage of raw materials. We don't always have big piles of raw materials sitting in our warehouses. Instead, the production inputs and materials go directly into the production machinery to save time and to save money. These just-in-time or lean manufacturing methods are no less industrial processing because there isn't a big stack of raw materials. As a matter of policy...
Counsel, can I ask you about what exactly what you think the Court of Appeals holding was? I mean, when I read it, I think the Court of Appeals didn't hold that the machines are engaged in industrial processing or that the exemption specifically applies to them. It remanded to the Court of Claims to determine that. So I feel like this is all very interesting about how sub 3 and 7 interact, but when I read the Court of Appeals opinion, I feel like it didn't sort all that out, and it remanded to the Court of Claims to determine that. So should we really just be determining whether the Court of Appeals was correct when it said that the Court of Claims erred in finding that the plaintiff's container recycling machines could not be engaged in the activity because the machines do not perform their task after tangible personal property begins movement from raw material storage? I mean, if that's all we're deciding, that's kind of not what anybody's been talking about, but...
Well, what the Court of Appeals held is the department's argument that raw material storage is a precondition to industrial processing is wrong.
Right.
And that's absolutely correct, because it would really destroy many parts of the industrial processing.
It's pretty
exemption.
narrow, and if it remanded to the Court of Claims
remember what the Court of Claims said was, yes, these machines appear to conduct the activities under subsection 3. The Court of Claims found that. We do the inspection, quality control, we do some steps of recycling, but those can't qualify because you don't have raw material storage. So when you look at what the Court of Appeals said is, well, if you don't need raw material storage and we have the activities under subsection 3, these machines are doing industrial processing.
Well, that just means it'll be a really easy trip back to the Court of Claims for you.
Yes,
I'm just trying to get clarity on, what exactly you think the Court of Appeals holding was, and therefore what we're deciding today.
That's what I think they're holding us. What we ask this court to hold, even though you could hold, we meet this, there is some sort of raw material storage, we don't really want you to hold that. We want you to say the interpretation that you have to have raw material storage before you can have exempt industrial processing is wrong. Mm-hmm. The general rule of...
As long as you otherwise meet you're on the list under 3, right?
Yes. If you're on the list under 3 and you're doing it on behalf of an industrial processor and you can show that, which we have done down at the Court of Appeals,
right, all the other
Claims, and they sort of admit that, you don't have to have raw material storage so that we will qualify and many other industrial processors will qualify for the exemption. Any further questions?
Any further questions? Thank you very much.
Thank you very much. Appreciate your time.
The case will be submitted.